So hello everyone. Today marks our second lecture in our discussion for our upcoming prelims 2025, and as you can see on the board, today's theme is about the constitutional amendments related to fundamental rights. So this is not a session where we take up all the different articles of fundamental rights from 12 to 35 and discuss each article one after the other. Sheer waste of time. And why would I say it's a waste of time? It's because questions in UPSC are evolving. It's becoming increasingly difficult. They don't touch over such superficial level of knowledge from fundamental rights anymore. The reason is because I think UPSC has almost got exhausted by asking all the easy questions from fundamental rights. There is just so less room to ask easier questions in the upcoming years. And if you were to analyze the questions asked from fundamental rights in the last 2 years, that would show us such a trend, right? And there are around 14 or 15 different constitutional amendments which have altered the provisions of fundamental rights, right? And these are the different constitutional amendments. The first amendment, 7, 16, 17, 24, 25, 42nd goes on till 103rd Constitutional Amendment Act. So are we supposed to just mug up, memorize all these numbers and hope that such a memory would not fail you on the day of your prelims? I don't think so. But if you were to just look into the background behind these constitutional amendments, if you can just place the reason for these constitutional amendments in the right context, I'm sure the memory will just last for you on the day of your examination. And it's actually very easy. It's not so difficult to learn about each and every constitutional amendment, right? So that's what we are going to do in today's session. We are going to narrowly focus. We're just going to focus on these 15 amendments which have been instrumental in changing the different provisions of fundamental rights, right? And why would I choose such a question? Just because of the nature of questions asked from fundamental rights in the last two prelims. Let's take an analysis of 2024 and 2023 prelims. Let's have a look at the kind of questions asked from fundamental rights. So there have been around 4 questions asked from fundamental rights in the last 2 years. Okay, around 2 questions asked every year. And this is a question asked in 2024. I would say this is the only easy question of all the other questions, right? So the remaining questions on fundamental rights, I would classify them either as difficult or maybe one of them could be moderate or difficult. And let me tell you, these 2 questions have never repeated in the past, never been asked in the past. So these are very, very fresh questions asked for the first time. So that's why, and just preparing an answer for these is no guarantee that you'll be able to get the same question in the upcoming years and you'll be able to get it right. No, but having an idea, having a sense of where the questions take us to will definitely help you prepare. Look at other aspects of fundamental rights chapter with the same lens, as a result of which your preparation will be fine-tuned to the direction required to crack this prelims, right? And learning that is the objective of today's session. So why would I say this question as easy, the 2024 prelims question? Because it's a straight, direct question which almost every single UPSC aspirant will be aware of, right? And there's nothing to cheer about it, because if you are capable of getting it right, so will everybody else as well. So there's nothing, no competitive edge that you alone gain because of getting this question right. Just a level playing field for almost every other aspirant. But if only you can handle these 3 questions smartly, even if you were to leave one unattempted, get one right and get one wrong, I would still say that's a winning combination, because these 3 questions, all 3 of them were asked in 2023 prelims. And what was the cutoff in 2023 prelims for general category? Just around 75 or 76 marks, which means that it's just 35% was all that you need. And this is the combination. Leaving one attempted, one unattempted and one incorrect would still guarantee you 35% of the marks, right? If the same kind of performance can simply repeat across all papers, all subjects, definitely you would have crossed the clearing cutoff. But it's not so easy to do that. There is a higher possibility of going wrong. There's a higher possibility of simply just leaving it unattempted if you haven't prepared for the difficult aspects on fundamental rights. If you have been very, very narrowly confined to simply the awareness of what article and what does it actually what is the corresponding provision, if your knowledge was only to that first level of awareness, I don't think you could have got any of these 3 questions right. So there's a lot of background work which should have been done when you approached all these topics as a course of in the normal course of your preparation on fundamental rights. So anybody who reads Article 21 would have come across the phrase procedure established by law, and you would have also known that procedure established by law was replaced with the new concept of due process of law in Maneka Gandhi case, right? At that time you should have had a very clear idea of what is the spirit of this phrase due process of law. Okay, what is the constitutional difference between the treatment when you use the phrase procedure established by law versus due process of law? If you would have already given a thought, getting this answer on the day of the exam correct is possible, right? Today it's easy to just give an answer for all this and make some grand discussions on that, but that serves no purpose. And similarly, if you would have been very careful to have understood the intent behind the different constitutional amendments, you could have got this question right. Right? I'm not asking you to know all the different constitution amendments enacted to make changes to our constitution. I'm only asking you, have you ever approached at least the constitutional amendments to fundamental rights from that perspective? Have you taken care of knowing the historical background and the reason why these amendments have been brought into place in the first place? Even to that extent, if you were aware, getting this answer right would have been made possible. Else you couldn't have got this answer right. And in fact, even the UPSC key has withdrawn the correct answer for this question. Basically, the question was withdrawn. Why? Because UPSC itself feels that there could be a conflicting opinion between option A and option B, right? So such is the nature of question, where even UPSC cannot arrive at a concrete answer. And similarly, we have this particular question number 19, asked in 2023 civil service exam. Here, statement 2 alone is relevant to fundamental rights. This is also another way of how UPSC is making the questions on fundamental rights difficult in the recent years. What it does is it asks a question from fundamental rights, but it's not a standalone question only on fundamental rights, right? Only one statement out of the 3 actually can be handled by reading Lakshmikant's chapter on fundamental rights. Okay, the third statement not at all present in Lakshmikant. So what happens is, all the time that you have invested in strengthening and mastering fundamental rights now goes waste. Why? Because the third statement makes the question unattemptable, and the nature of options is framed like that. It's not the conventional type of 1 and 2, 2 and 3, 1, 2, 3. That's not the type of options that we come across here. As a result of which this question becomes unattemptable. You cannot attempt this. So it's only either of the two have to be attempted. Right? Great if you can correctly attempt the right question and leave the other one unattempted. But at least you should have the sense to not get both the questions wrong, right? So that is why I feel it's necessary that we move on to the next level of knowledge acquisition from fundamental rights. So the primal level, where you just know what is Article 12, what is Article 13, what is Article 14, what is the 5 different writs. Just that awareness is not going to take you places, if at all this kind of a question paper is to repeat in the upcoming years. So that's the entire objective of today's session, and let's get into the session. So just take a minute or two, think about if you are in the position to answer these questions right. So you feel that you have prepared adequately on fundamental rights. So if that's the case, why don't you give me answers for these questions? If you are in a position to give me answers for all the 3 questions right now, it's great. I'm sure you don't even have to watch the upcoming part of the lecture. You can save your time. But if you do not know the answer for these questions, it's very important that you actually pay attention to what I have to say in the next 45 minutes or 1 hour, right? So just take 2 minutes of your time, think about the answers for these questions. If not, at least take a screenshot of this particular slide, and maybe once the session is over, when you once again have a relook at this particular question, 3 questions, you will be able to get the right answers. Okay. Take 2 minutes of your time to think about an answer for this question. Okay, let me give you the answers for this right now, and I'll discuss why these are the answers. You will find the explanation in the part of our discussion to follow. The right answer for this question is 1, 2 and 3. And for this question, the right answer is to suppress secessionist trend in the country. And for this, the right answer is changes to the 7th schedule, 66th Constitutional Amendment Act. So, you are supposed to get this answer not by knowing about 66th, but by knowing that 16, 25 and 103 wouldn't fit into this scheme of things. You should know that 16th Amendment Act, what is the objective behind that? Did it make any changes to the 7th schedule? No, it did not. 25th Amendment Act, questioned in Keshavan and the Bharati judgment, why would it even have anything to do with 7th schedule? So, exclude it. 103rd Amendment Act, it's a reservation for EWS, why would it make changes to 7th schedule? Exclude it. It's by exclusion, and to exclude these you need to have knowledge on 16th Amendment, 25th Amendment and 103rd Amendment. All these amendments have made changes to fundamental rights. So, the knowledge can even help you in exclusion, even though you may not precisely know which is the correct answer, right? So, option C as an answer for this question, option B Bombay, and option B Bombay again. So, these are the answers, and let's find out why I would say that these are the answers. So, let me get you into the discussion by narrating you a context of 1950. Let's assume today is 1950, right? The Indian Constitution had just come into force, and after that the government in Madras comes up with a government order. So, the Madras government GO, it actually provides for reservations for non-Brahmin backward caste groups in medical and engineering colleges. And as soon as this GO was made public, a Brahmin student by the name Champakam Dorairajan, she goes to Madras High Court. She alleges that her fundamental rights guaranteed under Article 14 and 29 Clause 2 stands violated. She says that Article 29 Clause 2 guarantees that no citizen shall be denied entry into an educational institution on certain grounds. And what are the grounds? On the grounds of religion, race, caste, language, or any of them. Race, religion, caste, language, or any of them. These cannot be the grounds on which a person can be denied admission into an educational institution. And Champakam Dorairajan says that because of this Madras government order, I being a Brahmin, I am being discriminated against. So, which means that I am being discriminated from being an entry into education institution on ground of caste. It violates my right to equality, and the court agrees with her. The court strikes down the Madras GO as invalid. The Madras government goes on appeal to Supreme Court, loses the appeal as well. So, it means that the state governments cannot carry out any affirmative actions in the form of reservations, right? Not only that, the central provinces government, which is today's Madhya Pradesh, they came up with a law. And what was the law? The law restricted employment of workers as BD factory workers during agricultural season. Why? In the BD factories they get higher wages. In agriculture they get lower wages. So, they don't want to do agriculture. They would be happy going and rolling BDs in the BD factories. As a result of which the state agricultural production comes down. So, the government decided to stop that. It placed restrictions that during agricultural season, no BD worker should be employed in the factories. So, the BD workers and the factory owners, they went to the Supreme Court. They said that such an order of the government violates their freedom. What freedom? Article 19 guarantees the freedom to practice any profession or to carry any occupation, trade or business. So, since this government order violates my Article 19 freedom, please declare it as invalid, and hence the order of the central provinces government was struck down. So, it means that the governments cannot even prioritize what should be the priority for the state, right? Even the government orders of both Bihar as well as UP governments, where they tried to bring in zamindari abolition laws, was also put on hold. The Allahabad High Court as well as Patna High Court, they passed restraining orders against their respective state governments. They said that do not carry forward with your land reforms until we finish hearing these matters on zamindari abolition, because zamindari abolition acts passed by those governments were questioned, they were challenged that they were violating their right to property of big zamindars. So, it means that even progressive legislations which aimed at land redistribution cannot also be carried out. Basically, it means that none of the directive principles can be carried out, none of the directive principles of the Constitution can be given effect. It's because of the stumbling block of fundamental rights. And not just that, even if a state feels it is a threat from a citizen, the state is now so powerless that it cannot safeguard itself. I'll give you an example for that. Article 19 clause 1 talks about the different freedoms available. Article 19 clause 2 to 6 talks about the grounds on which all these freedoms can be restricted. If you were to look at the original constitution passed in 1950, you take clause 2, which had the different grounds on which the freedom of speech and expression can be restricted. These were the original grounds. It had grounds like libel, slander, and overthrow of the state. So these were the grounds on which the freedom of speech and expression of a person can be restricted, right? Just these three, nothing else. But today's constitution has so many other grounds here, right? How did it happen? Because of the first Constitutional Amendment Act, which I'll be discussing soon, right? So what happened here was that there were so many writings, there were so many publications which carried such critical remarks against Jawaharlal Nehru's government. Especially critical were the publication of the Communist Party, which went by the name of Crossroads. It was an English monthly magazine. And similarly, RSS had their own English magazine called as The Organizer. So both these publications were highly critical to the extent that people would get inflamed when they read such kind of articles. And these leaders, communist leaders, they used to go around carrying a copy of Crossroads with them, and they used to stand in public and make speeches which has the potential of inciting the crowd, right? So that's why Nehru government felt that censorship should be ordered on these publications, and that seems to be an assault on the freedom of speech and expression of the press. So Crossroads went to the Supreme Court, filed a case, and Supreme Court came down heavily on the government. It said that these three grounds do not apply to criticism against the government. Yes, such criticism may lead to public order issues, but public order is not a ground under which restrictions can be placed on the freedom of speech and expression. So it means that even though speeches can be very vitriolic, even though speeches can be very, very damaging to the established government, still the government has to sit quietly, let people speak. It means that the government cannot even safeguard itself. So in 1950s, we are in a context where the governments cannot carry out any welfare measures. The governments cannot prioritize their development needs of the state. The governments cannot create any affirmative actions for the disadvantaged sections of their population, and the government cannot even protect itself from very, very damaging speeches made against it, right? So it was in this background in 1950 when Nehru decided to act, because elections were simply round the corner. Elections were due in the winter of 1951 to 52. That was the first parliamentary elections to ever happen in this country. So Nehru's Congress government now has to go to the people with some track record. They have to provide for zamindari abolition. They have to provide for reservations, because all these were tall promises made by Nehru since the elections of 1937, right? So Congress was first elected to power as per the Government of India Act 1935 in the year 1937. Since then, the Congress government has not fulfilled all its promises completely. So that's why it's very urgent that immediately some solutions have to be given to all these problems, because Nehru cannot simply go to the people and give constitutional excuses that Constitution has Article 13 which allows Supreme Court to negate a government action. All these excuses will not cut slack with the common man. The common man wants results. The common man wants his life becoming better. Common man wants a piece of land in his own name, right? So that's why it becomes very, very urgent and immediate that some kind of a mechanism has to be found to resolve all these problems. And that mechanism, according to Nehru, came in the form of first constitutional bill introduced. And mind you, there was no parliament at that point of time, right? The first Lok Sabha is yet to be formed, and it's only when the state assemblies are formed the Rajya Sabha can even be convened. The first Rajya Sabha was convened only in the month of June 1952, but the first constitutional bill became an act in 1951 itself. So it means that it was never passed by Lok Sabha and Rajya Sabha. It was simply passed by a single house, which was nothing but the provisional parliament itself, right? So it was the same provisional parliament which actually enacted the first Constitution Amendment Act. So what was the objective of the first Constitution Amendment Act? It widened the scope of the grounds on which freedom of speech and expression can be restricted, right? So all these narrow grounds were all removed. Now a few more grounds were added, on the basis of which a freedom of speech and expression available to an individual can now be restricted, right? So today you have multiple different grounds on which your freedoms can be restricted. So all of that, the credit goes to the first Constitutional Amendment Act, right? So what are the grounds? Friendly relations with foreign states, public order, the same public order which was not accepted by the Supreme Court, right, in the Crossroads case, now became a part of the Constitution. Now the government has a valid ground. Now the government can always censor such speeches. such writings on grounds that it can be detrimental to public order, which was earlier impossible but now made possible because such a wording has now been added to the Constitution as a result of the First Amendment Act, right. So all these different grounds today found in clause 2 was the outcome of First Constitutional Amendment Act, right. And not just this, it was the same very first Constitutional Amendment Act which made amendments to Article 15. It's because of amendments to Article 15 a new clause was introduced, clause 4 was introduced, as a result of which reservations for socially, educationally backward class of citizens and SCs, STs were made possible. If not for this amendment, today none of these groups would enjoy reservations. And not just this, even the problem of land reforms was rectified. How? 2 new articles were inserted, Article 31A, 31B. These 2 articles introduced as a result of the First Constitutional Amendment Act. It added exceptions. What kind of exceptions? If at all any state government was to acquire land for the purpose of land reforms, large estates, if at all they are now acquired, they now enjoy protection. They cannot be declared by the judiciary as null and void. So this was another protection guaranteed because of First Constitutional Amendment Act, right. So these are the key features of First Amendment Act. So basically it's an act that solved a lot of problems present back then. Now moving on to other important constitutional amendments, the 16th Constitutional Amendment Act, right. So it's as a result of this amendment, today the freedom of speech and expression of a person can be restricted on grounds that your speech can cause problems for the sovereignty and integrity of India. Let's say I have a secessionist tendency and I get elected to parliament or to state legislatures, right. So inside the parliament and state legislature there is a considerable amount of freedom of speech and expression, but that doesn't mean that you can talk whatever you want. Even though it may be parliament, you cannot advocate for secession of a part of your country from India itself. This was basically targeted at DMK, because in Madras, starting from 1957 elections, the Dravida Munnetra Kalagam, the DMK party, was slowly rising in its poll performances. And the DMK leaders, after assuming the role of MLAs, they used to enter into legislatures, and from within the legislatures they used to give calls for a separate Dravida Nadu, which means a separate Dravida state, right. So such kind of tendencies was attempted to be curtailed, and that's why the 16th Amendment Act was passed, right. Why was it passed? So as to prevent any kind of speeches that has an impact on the sovereignty and integrity of India. I may get elected as a MLA or a MP, and after getting into the legislature, if I were to make speeches for dividing this country, that kind of speeches should not be allowed, even if it is made in the floor of the house, right. So that's why a new restriction was inserted into clause 2 of Article 19 as a result of the 16th Constitutional Amendment Act, right. This is another amendment act which is worth remembering, but I believe now you can remember it because this act was passed targeting the DMK MLAs and MPs, and it was passed especially in the context of the aftermath of Indo-China War of 62, right. So this act was actually passed in the year 1963. Why? Because during wartime the government had decided that such kind of speeches may have the effect of creating divisions among the people with respect to their loyalty towards their motherland, right. When a group of MLAs or MPs, when they start advocating for secession, that's really damaging to the integrity of the country. So that is the reason why 16th Constitutional Amendment was passed, adding a few more grounds restricting the freedom of speech and expression on grounds of sovereignty and integrity of India, right. So the next Constitutional Amendment Act made to Article 19 was the 44th Constitutional Amendment Act, which you all know, which eliminated a provision, right. So there was a fundamental right of property, since that was becoming the ground for protracted litigations in the court. It was this property issue alone which was constantly becoming a headache for whichever governments that they come to power. So finally the Janata government, which came to power in 1977 elections, though they had a short span of tenure for just 3 years, it was a Janata government which removed the right of property from a fundamental right. It took it to Article 300A, a new article was created, so that today the present position of property is that it's not a fundamental right, it's simply a constitutional right. So 44th Amendment Act had also had its impact on Article 19, right. And lastly, the 97th Constitutional Amendment Act also had made amendments to Article 19, where a right of formation of cooperative societies was created. So now a citizen need not be dependent upon a state to allow cooperative societies to be formed. He can now have a claim on the state. He can actually go to the court and say that my state government is yet to form cooperative societies. So it's to strengthen cooperative societies. It is to create it as a matter of right rather than the matter of discretion of the state governments. It's for that purpose 97th Amendment Act was brought in place, right? So these are all the different constitutional amendment acts which had its impact in amending Article 19. The First Amendment Act, majorly, it had its impact on the grounds, insertion of new grounds on which freedom of speech and expression can be restricted. 16th Constitutional Amendment Act, which also brought one more ground for restriction of freedom of speech and expression, the grounds of sovereignty and integrity of India. And then the 44th Amendment Act, which took out property, made it as another constitutional right, not as a fundamental right. And 97th Amendment Act, which had its impact in the form of giving a right to citizens for formation of cooperative societies, right? I hope it's simple, right? First Amendment, 16th Amendment, 44th, 97th Amendment Act. These are the amendments pertaining to Article 19, right? So we'll just move on. So I've already discussed the impact of First Amendment Act on Article 15, right? I've told you that a new clause 4 was introduced as a result of First Amendment Act, which now has the impact of providing reservations for socially, educationally backward class of people, for SCs and STs in state-run institutions, right? So that part, we are fine with that. That is taken care by the First Constitutional Amendment Act. There are also two other Constitutional Amendment Acts which have had impact on Article 15. One is Article 93rd, other one is Article 100 one is 93rd Constitutional Amendment Act and the other one is 103rd Constitutional Amendment Act. So what are these? We'll start with 93rd Constitutional Amendment Act. So this was an act which was passed as a response to two landmark Supreme Court judgments. One was a judgment called as the Unnikrishnan case judgment. Unnikrishnan case judgment is an example of judicial activism. And you know what is judicial activism? It's basically the liberal way in which Supreme Court interprets Article 21, as a result of which newer and new rights are born out of Article 21 because of the jurisprudence of the Supreme Court, right? So because Article 21 is very short, it's phrased in such a way that it doesn't have any scope for expansion. It simply says no person shall be denied of their right to life and liberty except under procedure established by law. But this Article 21 has now come to be interpreted by Supreme Court in multiple different ways, as a result of which so many new rights have been born out of Article 21. Right? Today, if you talk about right to clean environment, right to livelihood, right to travel abroad, all those exhaustive list of rights that you actually find in your Lakshmikant is the result of judicial activism. And one such example of judicial activism is the case Unnikrishnan case, in which Supreme Court had said that right to education is also a part of right to life. It is only because Supreme Court coming up with this judgment, today we have Right to Education Act. If not for this, today we may not even have had a Right to Education Act. So RTE was the outcome of Supreme Court creatively interpreting Article 21 to bring in a new right of education under the fold of Article 21, right? So Unnikrishnan judgment gave a verdict that right to education should be the next priority of the state, and the state clearly knew that it has limited number of schools, and with its limited number of state-run schools, it cannot give education access to all children. So that's why the state had a brainy idea. The idea is, why don't we just make it compulsory that even private educational institutions, right, even in private educational institutions, reservations have to be provided. Reservations for whom? It could be for socially, educationally backward class of citizens. And that's why we have the compulsory quota in private schools, that they must admit a certain percentage of students from the neighborhood, from poor families, right? Why do you think it's made possible? It's because of Clause 5, which was inserted as a result of 93rd Amendment Act. And why was 93rd Amendment Act enacted? One of the reasons is because Supreme Court had made right to education as a fundamental right, and now the state has to give effect to that. But if the state has to give effect to that, it doesn't have so much of schools that on its own that it runs. That's why it has to take assistance of the private schools, private educational institutions. But do you think they'll simply open up the doors? They won't. That's why you need to have a constitutional provision which allows state action to mandate that certain amount of reservations of seats have to be provided for socially and educationally backward class of people, and that is why clause 5 was inserted to article 15. So this is another amendment act which is really worth remembering, right? And lastly comes the 103rd Constitutional Amendment Act. So you know about it. 103rd Amendment Act is the amendment which provides reservation of seats for economically weaker section of the society, and this particular amendment act was even challenged in the Supreme Court on various grounds, right? Because the EWS reservation does not apply to backward caste groups, it doesn't apply to SCs and STs. So their reservation is separate, EWS quota is separate. So somebody from OBC or from SC or ST background, they cannot actually aspire to get through EWS. So such kind of conditions were all challenged in the Supreme Court, and the Supreme Court upheld the correctness of this constitutional provision, right? Let me not get into the logic behind all of that. That's like a huge debate again. But you should just simply know that 103rd Constitutional Amendment Act created one more reason to provide reservations. The earlier reservation reasons were social and social and educational backwardness of a class or a caste, scheduled caste being a SC or a ST, right? So these are the only grounds which are permissible earlier. Right now in 103rd Constitutional Amendment Act, a new ground which is basically completely based on economic criteria. Until now, it's not an economic criteria, it's basically socially and educational. Social and two conditions have to be simultaneously satisfied, because there could be some caste groups which may be very dominant in the community, right? But they may just not have achieved enough educational accomplishments, right? So if that is the case, they don't enjoy reservations. Two factors, two disabilities should be simultaneously at work. One is social backwardness, second is educational backwardness, right? So such kind of conditions were what were imposed as a result of clause 5 brought into article 15 as a result of 93rd Constitutional Amendment Act, and clause 6 allows the state to make reservations for economically weaker sections. So this is a criteria which is completely based solely on economic backwardness. There is no social indicator which is actually brought in as a factor of reservation, right? So easy. 15th article of the Constitution, it prevents discrimination on certain grounds, but at the same time new clauses have been added which allows discrimination to happen for the benefit of certain classes of citizens. Who are these classes? Those classes who suffer from social and educational backwardness, those classes which are scheduled caste and scheduled tribe, and those classes who are economically weaker sections. And which of the amendments have taken care of these? The First Amendment, 93rd Amendment and 103rd Constitutional Amendment Acts, right? So let's revise. Article 19 was amended as a result of various amendments. What are they? As usual, it's the first Constitutional Amendment Act which added a lot of grounds on which new restrictions can be placed on freedom of speech and expression. Apart from that, you had the 16th Constitutional Amendment Act which brought in new grounds like sovereignty and integrity as a ground for restricting your freedom of speech and expression. And then comes the 44th Amendment Act which takes out the right of property. And then comes the 97th Amendment Act which creates a right to form cooperative societies. That's Article 19, freedoms. When it comes to Article 15, three constitutional amendments have had its impact. First Amendment Act as a result of Champakam Dorairajan case. Second is the 93rd Constitutional Amendment Act as a result of Unni Krishnan and TMA Pai Foundation case. And then the 103rd Constitutional Amendment Act, which is simply to provide reservation for weaker sections, right? So let's move on to the next article. The next important article that was amended as a result of these constitutional amendments were the exceptions to fundamental rights. And where were the exceptions provided? They were provided in 31A, 31B, 31C, all three of which were introduced as a result of constitutional amendments. And why were these exceptions even introduced in the first place? 31A, 31B were introduced as a result of the first Constitutional Amendment Act, so as to allow land redistribution by abolishing zamindari system. How do you abolish zamindari system? By placing ceiling limits of land, which means that you're interfering with a person's right to own property. If I were to own 5,000 hectares and now government says you can only own 100 hectares, it's basically they are interfering with my right of property, right? So it means that now the legislation stands a chance of being invalidated by the court. So you are protecting it. How do you protect it? By creating an exceptional clause, which is provided in 31A and 31B. 31A allows a state action for the purpose of zamindari abolition, for the purpose of land distribution. If the government were to deprive a person of his property, then in that case there is no challenge possible in the court, right? So you should understand that there is a purpose clearly specified in 31A. The purpose is for the purpose of land distribution, and large estates can be acquired for that purpose. This was what was the language of the first Constitutional Amendment Act. And it also introduced 31B, which is nothing but a list of laws which are now immunized from being reviewed by the judiciary. It's basically you are giving a constitutional protection by keeping it beyond the purview of judiciary, right? So 31A, 31B introduced as a result of the First Amendment Act, and that did upset a lot of people. A lot of landowners were upset because of this. So that's why one big landlord, Shankari Prasad, he went to the Supreme Court and filed a case challenging the correctness of the First Amendment Act. So he asked the Supreme Court, what right does the Parliament has to amend fundamental rights itself? But thankfully Supreme Court gave an answer on behalf of the government. It was more favorable for the government, as a result of which land reforms just happened, right? So land reforms continued till 1964, when the 17th Amendment Act was enacted. And why was it done? It just simply widened the scope of land acquisition possible, right? I told you earlier, land acquisition can be made of large estates. If a zamindar had 10,000 hectares, a portion of that can be taken by the government, right? But in this last 14, 15 years, the work of the governments have increased. The government has to now acquire small patches of land from small farmers. And why does the government have to acquire small patches of land? Maybe to construct airports, maybe to construct industries, right? But as of now, the Constitution does not have any provision for acquiring small pieces of land under the personal cultivation of the farmers. So that is the reason why 17th Amendment Act was enacted. It brought personal land under personal cultivation, even if it's a small land, also within the scope of land acquisition, right? It is simply to enable the government, it is simply to provide the government with a constitutional basis to go and acquire land, even though it is under personal cultivation. That's the reason why the 17th Amendment Act was enacted. And this was challenged in the Sajjan Singh's case. But the majority judges had upheld the validity of 17th Amendment Act, even though only one judge, Justice Mudolkar, he had raised a point of dissent. He said that, what is this? It looks like as if there is nothing sacrosanct about fundamental rights. It seems like everything about fundamental rights can simply be amended. And it is Justice Mudolkar's dissenting opinion, which 10 years later, right, in the Keshavananda Bharati judgment, will become the majority opinion of the judges. At that time, Justice Mudolkar's lone dissenting opinion in Sajjan Singh's case, the majority judges of Keshavananda Bharati judgment, 7 judges will toe his same line, right? So let's not go into the details of basic structure doctrine, right? So 17th Amendment Act also made changes to Article 31A, widen the scope of acquisitions, right? And next comes the 25th Amendment Act, which was passed in the background of Indira Gandhi wanting to prove to judiciary her socialist commitments. Basically, Indira Gandhi became the Prime Minister after Lal Bahadur Shastri's death, and when she became the Prime Minister, she made a series of legislations which were all opposed by the judiciary. It could be the Bank Nationalization Ordinance, it could be Privy Purse's abolition, right? All of these were just negated by the judiciary. And not only that, the judiciary during this time, in its Golaknath judgment, it simply had overturned its stance in the first Constitutional Amendment Act case. In Shankari Prasad, judiciary said 31A is valid. But suddenly in 1967, in Golaknath case, judiciary says, no, First Amendment Act itself is not valid, right? Which means that land reforms cannot happen anymore. All of this frustrated Indira Gandhi. She wanted to directly take the judiciary by its horns. So that's why she passed the Constitutional Amendment Act, 24th Amendment Act and 25th Amendment Act, making a series of amendments to Article 13 of the fundamental rights. Also, she made changes to Article 31C. A new article was introduced, 31C was introduced as a result of 25th Constitutional Amendment Act. So, Indira Gandhi years, two new amendments were passed. One is the 24th Amendment Act and the 25th Amendment Act, both passed in the year 1971. So, 24th Amendment Act, what did it do? It made changes to Article 13 of the fundamental rights. What kind of change? It introduced a new clause to Article 13. Right? Just have a look at this clause. It says nothing in this article shall apply to any amendment of this constitution made under Article 368. It means that from now onwards, the judiciary cannot strike down constitutional amendments as invalid. Right? Because Article 13 is for the purpose of declaring the laws inconsistent with fundamental rights as invalid. And here she is adding a clause which says this power of judiciary which arises out of this article to declare a law inconsistent with fundamental rights as invalid does not extend to constitutional amendments enacted as per the procedure given under Article 368. What is the procedure? By following a special majority process, by following a special majority and the ratification of the states. If you were to make such amendments, judiciary cannot strike it down just because it violates fundamental rights. So she is trying to create a protection for constitutional amendments, right? So this was one of the amendments that was done by Indira Gandhi in her 24th Constitutional Amendment Act of 1971. And what about the 25th Constitutional Amendment Act of 1971? In the 25th Amendment Act, she adds a new clause, new Article 31C, right? What is this 31C? It's just very similar to 31A. While 31A tries to give protection just to land acquisition laws, 31C is very wide. It says that not just land acquisition, any state action that gives effect to directive principles which are enshrined in Article 39B and C. Right? What are these directive principles enshrined in 39B and C? These are basically very socialist principles. So 39B and C talks about nationalization, right? So tomorrow the government can pass laws and it can just take over Reliance. It can just nationalize and make Reliance Industries Limited as a state property, right? So that is 39B and 39C. So basically Indira Gandhi is trying to protect her nationalization efforts by introducing 31C, right? At least 31A is very narrow in scope. It only deals with the small limited topic of land acquisitions alone. But 31C is very wide. 31C allows any kind of state action to give effect to directive principles under 39B and 39C, right? If such state actions are carried out, they also enjoy protection. They cannot be invalidated by the judiciary, right? So that was the provision added by the 25th Constitutional Amendment Act, which will be challenged in the Keshavananda Bharati case. A small part of that will be declared invalid. I would leave it to you to go and find it out what it is, because once you start discussing it, the session just keeps expanding, right? So First Amendment Act, 17th Constitutional Amendment Act, they both deal with 31A. 24th Constitutional Amendment Act is an amendment to Article 13, inconsistency with fundamental rights. In that a last clause was added protecting constitutional amendments from being declared invalid, right? And then comes 25th Amendment Act, which introduced a new article itself, providing for a new set of exceptions for such state action which is directed at giving effect to DPSP under 39B and 39C, right? So that's the scope of 25th Amendment Act, right? And then follows 42nd Constitutional Amendment Act, which again expands the scope by ensuring that why should the state action be limited only to DPSP under 39B and 39C? Why can't we just expand it to all DPSPs, right? any DPSPs, if the state wants to implement, it can simply violate fundamental rights. So that's the substance of 42nd Amendment Act, which will be declared as invalid. So it's not of much use to us, right? So as of now, let's just try to recollect all the important articles of fundamental rights which were impacted as a result of constitutional amendments. Going in a sequential order, Article 13, right, we just saw it now. Article 13 was impacted as a result of 24th Constitutional Amendment Act. A new clause was inserted to protect constitutional amendments from being declared invalid. And then comes Article 15, which provides reservations for social and educationally backward class of citizens. Right? Article 15 was impacted by the First Amendment, 93rd Amendment, 103rd Amendment. Then came Article 19, which we saw. All the different freedoms, different grounds that were introduced as a ground of restricting the freedoms. Which were the Constitutional Amendment Acts relevant to restriction of freedom? The First Amendment Act, 16th Amendment Act, right? And then 44th Amendment Act, which took out the right of property, and finally the 97th Amendment Act, which introduced a right of cooperative societies. So these are all relevant, right? So this is how, when you keep progressing with your learning, try to keep recapping, right? Try to have a recap of whatever has been covered. So continuous recap will keep the memories connected with each other, right? And when it comes to 31A, 31B, 31C, the relevant constitutional amendments are First Amendment, 17th Amendment, 24th, 25th, and 42nd, right? So these are all the relevant amendment acts, right? So we have one other article where a significant number of amendments were brought in. That's nothing but Article 16, which talks about right to employment. Now we come almost to the last end of our discussion for the day. So this is an important article which I think I'll have to do some amount of writing to explain. It's because this is an article which the constitution makers have ensured, have kept here, so as to ensure that there is a protection given to backward classes, to scheduled caste, scheduled tribe, when it comes to government employment matters. Just be very careful about the wording here. There shall be equality of opportunity for all citizens in matters relating to employment or appointment. Two words here. One is, this article protects the interest of SC, ST, backward classes when it comes to getting entry into government services. But after entry, does it mean that these sections, these people can simply be abandoned by the state? No. That's why we have the word matters relating to employment, which means transfers, which means leaves, which means promotions. In all these matters, Article 16 is trying to ensure between a Dalit and a Brahmin, there is going to be equality of opportunities, right? I'll give you an example explaining all of that. Okay, so we have so many different clauses which are there in Article 16. I'm just trying to say that our country is so feudal, it's so backward minded that if not for this article, I'll tell you what will happen. What will happen is, there could be a head of the organization, maybe he's a secretary who is from some general caste, right? And there are two new officers, one of them is from his caste, the other is from a scheduled caste. Now what will happen is, if at all this article would not have been there, this man from his same caste will be swiftly promoted, he'll be given nice leaves, he'll be given study leaves to go abroad and pursue some career, whereas this man will never be given an opportunity to improve himself in every way that this man is able to do that. So that's why the way you have to visualize Article 16 is that it not only protects, it not only gives opportunity in terms of entry into government jobs, but also post entry, this article tries to protect the entrance in every possible way, right? And this particular article has been subject to so many amendments, right? I'll explain to you what those amendments are. First, when it comes to 7th Constitutional Amendment Act, and I'm sure most of you would be able to associate 7th Constitutional Amendment Act with reorganization of states, right? So this is an association that most of you will be able to recognize, right? So let's say when state reorganization took place, you see Andhra Pradesh as a state was born by bifurcating the state of Madras, correct? And in Andhra Pradesh you have two areas, the Telangana area, which is comparatively backward, right? Telangana is the interior part of Andhra, the earlier Nizam's territories, and then you have the coastal Andhra Pradesh, which is very fertile, very developed, right? This article allows a temporary solution. What is that? A temporary advantage for Telangana over Andhra Pradesh. I'll tell you what it is. See, let's say there are certain number of posts in Telangana, right? And I told you Telangana has always suffered from backwardness compared to coastal Andhra Pradesh. So coastal Andhra Pradesh has better education, better healthcare, better human development. So people there are more educated, there are more literates compared to Telangana people, right? As a result of which, any public service examination that is conducted in the state of Andhra Pradesh, the people from coastal Andhra will always be able to beat those from Telangana in competition. So it basically means that every post even in the Telangana region will all end up being occupied by people from coastal Andhra Pradesh. So it's like people of Telangana will always remain backward. They cannot gain entry into government services at all, right? This is what is now going to happen as a result of bifurcation of the states, as a result of reorganization of the states. There will be pockets of backwardness in every state, and for people from these backward pockets, you need to protect them from open competition, right? So how do you protect? By ensuring that residence as a criteria for appointment to posts is made mandatory. It's only for people who are residents in Telangana, which means the sons of the soils, right? Only they are eligible for certain class of posts. When you make these kind of conditions, you're able to protect their interests, right? So that is the substance why we have 7th Constitutional Amendment Act, which has brought in, it's here, so nothing in this article shall prevent the Parliament from, so this is the substance of 7th Constitutional Amendment Act, which has allowed the requirement of residence within the state or union territory to such employment or appointment. It's only if you are a resident of that state or union territory, only then you are eligible for appointment to those posts, right? So this is 7th Constitutional Amendment Act, which mandates the requirement of residence for employment to certain classes of posts, right? Let's move on to the 77th Constitutional Amendment Act, right? These three articles put together, these three articles can actually be clubbed together and it can be explained. What is 77th Constitutional Amendment Act? It provides for reservations when it comes to promotions, right? Let's take the case of Civil Service Examination 2025. You have all India rank 1, 2, 3, 4 as general, right? And maybe the next few ranks are OBCs, and let's say around the rank of 80 you have somebody who's a scheduled caste. So he is ranked number 1 among the scheduled caste candidates, okay? So now let's say there are a total of 150 officers. All 150 officers are posted first as assistant secretaries. Each ministry has 5 vacancies for assistant secretary. So all the 150 officers are accommodated as assistant secretaries. No problem here. When it comes to the next promotion, deputy secretary, right? So let's say there are only 10 posts of deputy secretary. So so can we say that we will fill all these 10 posts in the descending order of rank list? In that case, a scheduled caste candidate will never find representation as a deputy secretary. That is why the 77th Amendment Act mandates, even not only when it comes to entry into services, but also in promotions, reservations must be made for scheduled caste, scheduled tribe. That is the reason why out of 10 posts, let's say 2 posts will be reserved for scheduled caste, so that this person, even though he's lower in rank, can also have an equal chance of becoming a deputy secretary. Right? So there are only 10 posts. So let's say 1, 2, 3, 4. So all India rank 1 to 8, they are here. In addition to that, you also have all India rank 80 here, all India rank 120, who is also a scheduled caste candidate. Right? So these are the 10 officers now who are in deputy secretary rank. Okay. Now let's say it's time for promotion to become a joint secretary, and let's say there are only 3 posts as joint secretary. So let's say we promote by rank list. If that is the case, the first rank, second rank, third rank, they will now be appointed as joint secretary. No doubt about that. Once they are appointed as joint secretary, there are vacancies here. Now you have to fill in these vacancies. So you bring all India rank 9, all India rank 10, all India rank 11 are brought here. So once they are brought here, now just because they are higher in rank doesn't mean that they are senior to this scheduled caste officer, because the scheduled caste officer, even though he is in rank 80, he was appointed before all India rank 9, 10, 11 to the post of deputy secretary. So it means that he is the senior. Even though his rank is lower, he is now the senior. So when it comes to priority for promotion to the rank of joint secretary, over these people, it is the scheduled caste officer who now has a higher rank, higher priority. This is the idea called as consequential seniority, which is brought out in the 81st Constitutional Amendment Act. Right? So let me recap it again. The 7th Constitutional Amendment Act is simply to mandate residence requirement when it comes to employment in public services. 77th Amendment Act is to ensure, even when it comes to promotions, there are reservations provided for SC and ST representation. 81st Amendment Act is to ensure a scheduled caste officer, even though he is lower in rank, once he is promoted, he becomes a senior over a general caste officer who is promoted later than him, later than the SC officer, to the same equivalent post. That is what is called as consequential seniority. Right? And then there is one more Amendment Act, 85th Amendment Act. What does it say? It says that, so let's say, we'll take the same example. In the post of deputy secretary, I told you there are 2 posts reserved for scheduled caste. Right? So let's say in that year, not even a single scheduled caste candidate has cracked civil service exam. Okay, there are no SC candidates, which means that these 2 seats cannot be filled. If it cannot be filled, it means that for the next year, these 2 seats should be carried forward as 2 vacancies still remaining only for SC candidates to enter. These 2 seats cannot be merged along with the general pool. Right? It is to protect, carry forward vacancies and to make those vacancies available just for the benefit of SCs and STs alone. That is why the 85th Amendment Act was enacted. Right? 77, 81, 85, these are all for the purpose of, for the benefit of, for SCs and STs. Okay? So 77 is just for reservations and promotions. 81st Amendment Act is to provide for consequential seniority for a SC officer. 85th Amendment Act is simply to ensure that the vacancies that are unfilled do not get merged with the general pool. It's like depriving members from scheduled caste community their fair share of representation just because in 1 year there was simply no intake of SC officers. That doesn't give the government the right to erase those seats and make it as a part of seats available for general competition. That's not possible. Right? So this is how the Constitution protects the interests of vulnerable sections. And the latest addition to Article 16 was the 103rd Constitutional Amendment Act, which is nothing but providing reservation for members from economic weaker sections of the society. Right? Just like Article 15, where economic backwardness is used as a criteria to provide a reservation to enter into educational institutions. Similarly, EWS grounds, economically weaker section aspirants are provided a reservation to enter into public services. Okay, so this is all about Article 16, right? We just have one more article, which is nothing but a simple article, Article 21A, which is inserted by a Constitutional Amendment Act, 86th Amendment Act, which actually mandates that the state shall provide free compulsory education to children from the age of 6 to 14 years, right? So the same Amendment Act had introduced a corresponding DPSP as well. It had introduced a fundamental duty, right? So it has mandated a duty on the state. What is the duty on the state? That is DPSP. So 86th Amendment Act has mandated a DPSP where the state has to take care of children, early childhood care from 0 to 6 years old. And once they reach the age of 6, now it becomes a right of a child. It becomes a fundamental right under Article 21A to receive education. And all this can be only made possible if the parents are made responsible. That's why a duty is placed on the parents of the children so as to send their children to school, right? So all these three changes were effected because of 86th Constitutional Amendment Act. All right, so we are done with this unit on the different constitutional amendments that have amended fundamental rights. So if in case you are not able to understand a part of this, or if there was any complication arising out of any understanding, please do drop your concerns in the comments, or you can even send a personal message to me on my Telegram channel, and I'll make sure your query will be addressed. All right, so thank you.